All right. So, welcome to the Right to Privacy Law in India webinar hosted by Lawctopus India. My name is Ashna, and I'm the Content and Learning Manager at Lawctopus. It brings us immense pleasure to have Arpita here with us. As again informed, despite of the time difference, she's able to make it. She's in the US right now, and I'm really glad that you're here, Arpita. So just a bit introduction about Arpita. Arpita is a public policy lawyer who has keen interest in technology policy and business regulation. She is currently pursuing her master's in law and diplomacy at the Fletcher School, Tufts University, that is in the USA. Arpita has also previously worked with leading Indian law firms such as Shardul Amarchand Mangaldas and Trilegal in their TMT department, as well as public policy and regulatory affair teams. Arpita is somebody who's known name in the privacy law spectrum. And this webinar, I'm pretty sure and I hope that brings a light and touch base on the state of privacy law in India, which is much much talked about in India as of now. So Arpita, thank you so much for for being here. So do you want me to start with the polls?
Thanks, Ashna. Yeah, I think we can start with the polls. Thank you all for joining. I know it's a Friday evening, but I would love to know a little more about your background and if you have any kind of experience working in this particular sector, technology, media, telecommunications.
Great. So I feel everyone's participating. Almost 50% people are already done. So we have a fast team of people who are really keen for this webinar, Arpita.
Meanwhile, if you guys have any questions, feel free to use the Q&A box and I can address those questions. Okay, great. I guess it's a mixed bag here. So I do have lawyers, we do have law students here. We have professionals who are working in a different sector, and there's also other people who are interested in this space. I see that some of you do have experience in privacy, and I would love to hear from you all as well, what you guys are currently up to. And those who are new to this space, I assure you that this webinar will be helpful for you to kind of get a sense of what's happening specifically in India and also in other jurisdictions with respect to privacy law. So let me just share my screen. Okay, great. So just a little bit of background, as Ashna said, that I am a public policy lawyer and I'm currently pursuing my master's in the US. I've had a lot of experience working in this sector, and I've had the opportunity to work with different stakeholders on various issues related to internet policy, and some of which I will share with you all today. To go over what we're going to do today, I briefly want to kind of explain to you how technology has changed over the years and why privacy has become a really, really important topic for all countries to be discussing, and why digital products and services have new emerging risks when it comes to your right to privacy. And it's not just private companies that are offering these services, it's also the government. So we will look at both public and private sector privacy. And how we'll do this is that we'll first go through the constitutional aspects of the right to privacy, what kind of evolution the jurisprudence has witnessed. We'll also look at some of the key legislations which India has at present and which are being proposed or discussed right now. And we'll also look at a few similarities, dissimilarities in what other countries are doing when it comes to protecting the right to privacy. So as I said, right, like technology has really changed over the years. Some things what we used to do before technology, and like the definition itself of technology is quite quite elaborate, quite vast, and it covers not just your smartphones, but even like little improvements to what used to be before the evolution of technology, right? So be it just writing letters and sending them via post to email, which is probably like a very small speck in the whole universe. Today, we've kind of adopted many kind of digital identities, which could range from like your Facebook profile to having a bank account, right? So the entire journey from what used to be pre-digital era to a post-digital era, it's constantly evolving. The next set of the next world we're going to probably enter into is the metaverse, which also has newer risks and newer challenges which lawmakers will need to address. So if you look at the journey from the pre to post digital world, we've moved towards convenience. We've moved towards getting things done like in a faster manner, and sometimes more affordable manner, right? Like earlier we used to use paper forms for, say, getting a PAN card or anything, and now all of that has been digitized. And these create like unique data points about you. They give you information about who you are, where you're from, what you do, what your spending habits are, the way you interact with certain content, which could be of, say, political nature, or any kind of passwords you have to access these services. So your digital footprint today has kind of created a whole new profile about you. And both the private sector and the government has access to these data points. And these are used for providing better services and at times misused for various other reasons, right? So what I want you guys to do is that I'm going to share a Jamboard. A Jamboard is a document where you can kind of put little boxes of text. And what I would like you guys to write in that Jamboard is what privacy means for you. Why, like, how would you define it, and why it's important for you, right? So I'm just going to share that link. So if everybody could open the Jamboard, on the left side, there are little sticky notes which you can add. So feel free to use different colors. But what does privacy mean to you is what I want to kind of get a sense from you all. So this is what it looks like. And you can use a sticky note here and type whatever, why privacy is important or what it means to you.
So we already have 2 answers on the chat box. Arpita, do you want me to read the same for the people?
Yeah, sure.
Here? So Satvik Karan has to say, according to me, privacy is right to be let alone.
Okay, that's great. Would Satvik want to kind of elaborate on that? We can allow him to speak.
You can proceed with the next answer. Purva Sharma has to say, it is a basic human right which shall not be violated.
Mm-hmm.
And guys, anybody who wants to elaborate on their answer, please raise your hand. If at any point you have a question, please use the Q&A box. So we have Gautam who says, privacy is something which others need not and should not know and which do not harm anyone. So we have some interesting answers that are looping in on the chat box. We also have one question here. So guys, don't use the Q&A box to write your answer. Use the chat box to write your answer. Please refer to Q&A box only when you have a question.
Okay, great. So I'm going to share the Jamboard again, and we can see what people have written. So we have multiple answers here on the right to control the way I express my thoughts. We have not to share information with others about our lives. We also have sharing information about my phone number, medical records, and that is not shared with another company or another person, right? Okay, great. So I think all of us have a notion of what privacy means. We understand that it has something to do with our autonomy or our control over how we want the world to see us and what kind of access the world has to us, right? So when we talk about this control or autonomy, it refers to a choice we have. It refers to the choice about how we express ourselves, how we share information, what kind of information we want to share about our lives, our bodies, the people in our lives, or the places we go to. So many of the aspects of our lives, the control or how we exercise this control vis-a-vis the world is what privacy is all about. And at the same time, we are setting boundaries as to how people can access us, how companies and government can have access to our information, and it helps us define our relationships with other actors in the world. And it is also about protection. It's about protection against any kind of misuse of power or arbitrary use, unjustified use of that kind of power with in relation to the data or the information we want to share with the world. And at the end of the day, it is a human right. It's an inalienable right where you can live your life the way you want to. You can speak your truth or express whatever you want to without having to deal with some kind of discrimination or censure, right? So privacy as a whole, it has a lot of aspects to it. And when you look at it from the lens of sociology or even jurisprudence, there are these various aspects to privacy which courts have dealt with, which lawmakers want to kind of include or incorporate into the law, as well as the constitution, right? And in India, this right was not explicitly recognized till 2017, which we will discuss in a bit. But there has been the issue of privacy even pre-digital and post-digital era. And I think what has become more important is that because there are so many data points about us, because our digital identities have become so ingrained in our lives, the digital world creates new issues for us. And the pre-digital era, privacy was still an issue, and it could have still, it still existed in different buckets, I would say, right? So the kind of information we share with our doctor, or say the kind of privacy we had when just telephones existed, our conversations, wiretapping was considered to be a violation of privacy before cell phones even came into existence, right? So there has been some form of privacy even before technology kind of, transformed the world. But now, because we have so much of a quick access to sharing data or consuming content itself, this has become more problematic, or it has presented newer risks. I'm just going to check the chat. We see I have a lot of answers. Okay, does anybody want to kind of add on to what privacy means for them? Something you would like to share with the class which has not been discussed or mentioned on the Jamboard? Feel free to raise your hands.
So we have a question for you, Arpita, here on the Q&A box by Satvik Karan. So he asks, can we define the boundaries or limits up to which a person's privacy should not be invaded? Because sometimes it may lead to any particular situation which is uncontrollable.
Satvik, could you please elaborate on this? I don't particularly follow the question. I understand that, yes, privacy is about setting boundaries or establishing these relationships with the world, other people, on how you want to share information about you. But at times, yes, that there are circumstances which are unpredictable. There are uncertainties where your privacy may be invaded. And that is why there is a need for safeguards, right? There is a need for safeguards to kind of enforce these rights in case it gets violated by the state or say a private company. So for example, if there is a data breach, some jurisdictions allow users whose data has been infringed upon to get compensation or to be informed that their data was vulnerable to an attack or a breach, things like that. Does that answer your question?
All right, we have more questions coming up. So Satvik agrees with it. So the next question is by Swaminathan PS. How extent right to privacy is concerned and how Indian constitution ensure the right to privacy?
Yeah, we will be discussing that shortly. So let's just hold off on that question. We'll discuss what the Indian Constitution says about the right to privacy and the evolution of how the right to privacy became a fundamental right.
We have another question from Sohini Pal. Can we really define privacy in one word because it differs in every situation and in every perspective?
Yeah, I completely agree, Sohini. It's really difficult to define privacy because as we just discussed and as we saw in the chat on the Jamboard, privacy has so many aspects to it. It's really difficult to define the scope of it. But still, what you want to kind of understand is that at the end of the day, it's all about the freedom to do what you want to do. It's about the choice you exercise. And at the same time, it's also the protection you get from, say, the state, that your boundaries are not violated. So it is both a positive and negative right, if that's something you understand if you're a law student. So it's a positive right in the sense that the state ought to kind of enforce the protection of your right, and it's also enforced against the state in case there is, say, mass surveillance or any way the state invades your right to privacy. It is enforceable before the courts, right?
Let's take the last question and then we can continue with the webinar, Arpita. Okay.
Yeah.
So Shelly Agarwal has to ask, how does one come to know how much of their information is not private anymore? Juxtaposition of citizens' privacy with surveillance laws.
Right. Yeah, that's a great question, Shelly. It is really difficult to know how much of your data is out there. And this is largely because both private companies and even the government, when they ask you to kind of sign up to give your data, typically the consent which you give is not very well informed. We generally just, go through the terms and conditions and we just click the checkbox where we say, I accept. So at times you really don't know what kind of information about you are sharing and what kind of data is being aggregated about you. Because a lot of companies can take multiple data points and kind of infer or make inferences about you with that data. So at this point, given how much we use digital products and services, both by private and public sectors, it's really impossible to ascertain the how much of your information is available to the world. Which is why consent becomes really important, which is why your choice and control over your data becomes very important, where you can exercise control over what you can share and how your data can be used. And there should be the choice to also withdraw the data you've given or have that data deleted about you. So that's one of the burning topics which a lot of people are discussing, that there's really no way to ascertain how much of your life is even private anymore. So I'm going to share a short video which talks about what we just discussed and how this has always been an issue, and at the same time just give you a sneak peek into why privacy is important. And it's a really short video. Let me know if you guys can hear the audio.
So, what is privacy? Yeah, the answer to that question is pretty abstract, involving the rights of man and ancient philosophical thought, and frankly, too much introspection for a short animated web video. So no, let's ask another. Take a look at your phone. How much information about you is stored on it, and how safe do you think that information is? Do you shop online, exchange messages on social media, Google search, and perform general life simplifying tasks? Of course you do. It's almost impossible to participate in modern life without doing at least some of that stuff. And you probably lock your phone and keep it safe because, hey, you'd hate for all that information about you to be in anyone else's hands. Well, let's say it already is, because Google and Facebook and the store you shop at and the location app you turned on yesterday are all happy to collect and mine your information. And this isn't just your phone. This is your whole life. A pretty comprehensive picture of you is being built, which includes your history and future as well. And to be really clear, this isn't just the information you give them knowingly. In fact, you have very little knowledge or control over what information is being emitted. But we've got more. Thanks to new laws, new technologies, and certain whistles that have been blown, what we now know is that governments are not just watching terrorists. They're watching all of us. Your phone calls, your internet surfing, your emails, your social networking habits, your locations, even the fact that you're watching this video right now. All of it. Now, people don't always react as strongly as we do to all of this. We hear a lot of, they can spy all they like, I've got nothing to hide, and stop being so paranoid. And the question about how much all this will ever really affect you negatively is kind of why we made this series of animations in the first place. So for now, let's go back to the privacy thing. Privacy, and your human right to it, is the barrier that protects you from people doing things to you. It lets you manage boundaries, so you can open up to those you trust and shut out those you don't. It lets you maintain control. This is your right. But in the last 3 decades, very powerful institutions have tried to tamper with it. It's the individual's right to privacy versus the might and money of governments and corporations. Only the fight is in secret, and you don't even know you're taking part. They want to monitor you and make decisions about you, and they also push hard against laws that protect you. They do all this without public debate nor consent, and no one is overseeing them. I mean, this is where you're jumping off the ambivalent boat, right? Because privacy is about power. The more we have, the more power we have over our lives. And not to be overly dramatic, but throughout history, no system of mass surveillance has ever existed that has not ended up being abused. We have literally no idea where all this will end up. But the convenient solution we accept today will be the mandate of tomorrow. That's just how this works. Monitoring us, branding us, categorizing us, and profiting from us. Privacy can stop all this from happening. We can stop this from happening. Find out more at privacyinternational.org.
Right. So as we discussed, it's not just private companies that have your data, it's also the government. And the video specifically talks about how the history of mass surveillance has always led to some sort of a misuse or some sort of invasion to your right to privacy. And which is why there is the need to have enough safeguards in the constitution or in the legislation which can give you the chance to enforce your right to privacy. And as a citizen or as a digital user itself, these laws which India has, or even which the European Union has, they've made it vast enough so that people from other countries can also enforce these rights across the world. For example, the territorial applicability, right? The EU GDPR is applicable to all companies which operate within the EU. It caters to any company that offers services to EU users. So, which is why the territorial applicability of the EU GDPR is so robust that even companies in India have to follow that kind of compliance level. And again, this is very, very challenging because every company has different capabilities to protect your data. And some companies might not have the resources, some companies might not have the financial ability to comply with such extensive sets of laws. But at the same time, I guess, because privacy is so important, because it has a lot of protection for digital users, companies need to take that responsibility to protect the kind of data you share online and how they share with other companies or even the government. So the next part of what we're going to do in this webinar is to map how the Indian Constitution looks at privacy, to understand the evolution of the right to privacy as a fundamental right. We will be discussing the case laws which deal with the right to privacy. We'll also talk about the legislations which India currently has. And we'll briefly touch upon what other countries are doing with respect to right to privacy. Are there any questions which I can take before we move to the next part?
There are a couple on the Q&A box.
Yeah, I'm just checking that.
Yeah, there are about 2 questions. So Arpita, do you want to take the questions
Yeah, sure.
now? So Pankaj has to ask, is there any difference between privacy, public or personal? I'm not sure. Pankaj, could you elaborate on your question on the chat box maybe? Till then we can take the next question, Arpita.
Yeah, I think he's raised his hand, so maybe we
He's
can
raised his
allow him to speak. Yeah.
Okay, just a second.
First of all, thank you, ma'am.
Hi, Pankaj.
हेलो मैम। मैम मेरा एक क्वेश्चन था कि
हाँ.
जब हम बोलते हैं इट्स माय पर्सनल, इट्स
हाँ.
माय प्राइवेट एंड
हाँ.
इट्स अ पब्लिक मैटर, so is there a difference between personal, private and public? Many of times we are many of times we are listening, it's public matter, it's a private matter, it's a personal matter. So
Correct.
how to elaborate, and is there a difference between public, private and personal?
Absolutely. There is a difference between these different kinds of lives we have, right? We have a public life which we share with the world. It could be about, say our names or anything about us which we want to share voluntarily with the public. And there's also our private personal lives. There is a very thin line between that, but of course the kind of information we probably do not want to share with the world, right? Like maybe my income, or maybe the religion I practice, maybe my caste, things which are personal to you, which can identify you. Typically that is known as personal data, something that can identify you. And there's also another category of data which is sensitive to your life, which could have certain repercussions if the public knows that about you, right? Like your health information or your bank account number, thing like data points like your bank account number, or say your HIV status, things like that are very sensitive to your life and which should not be made public, which could have repercussions if made public. So there is a very distinct difference between all of these lives which you lead, which is why protecting your personal data, your sensitive personal data, becomes more important. And some categories of data needs more protection. For example, maybe just saying your name in public might not identify you, but at the same time, if you share information about your health or your bank account, it could identify you, it could help other people identify you, and that could have repercussions. So there is a difference between all of those. Let's go to the next question. Rohan, it's about your Aadhaar card. Yes, we will be discussing this in the jurisprudential evolution. So let's come to that in a bit. Komal, what is more fundamental, data privacy or data protection? I think it goes hand in hand, because while you enjoy privacy, there is a need for protection as well. So you need data privacy in the sense that you need control over your data, in the sense that you need to have the choice to give informed consent. You need to know what's happening with your data, who is collecting it, who is in possession of your data. And at the same time, that data needs to have a certain level of protection based on the kind of data. And that protection is really important so that you can enforce your right if there is any kind of violation.
So Arpita,
Right.
do you want to proceed with the webinar and take the questions for the Q&A session now?
Yeah, let me just run through the jurisprudence, and I guess some of the questions will get answered in that. Right. So if you look at the legislative frameworks at present in India, we don't have a dedicated law a privacy legislation or a data protection legislation as of now. What governs the protection, what governs personal data and sensitive personal data at present is what is known as the SPDI rules, which have been notified under the Information Technology Act. And these rules were passed in 2011. So I think a lot has changed, as we have discussed. So these rules kind of needed some sort of a reform. And I think because of the various privacy challenges which India has been facing over the years, there was a need to have a dedicated privacy legislation. And that is what the Personal Data Protection Bill now is a result of. So the SPDI rules at present is what is applicable to most companies who have to obtain consent from individuals if they are collecting and using sensitive personal data. So if they are using, say, your bank information or your health information, then they have added compliances which they have to follow. And at the same time, they need to protect this data as per international standards. So you need to have a privacy policy, which most of you must have seen whenever you sign up for a digital service or like any kind of online service. Even if you sign up for Facebook or you log into your banking app or say your Paytm, all of these services have something called a privacy policy. The privacy policy sets out the guidelines and the rules for what kind of information is collected about you, how that information is going to be used, where it is stored, who has possession of your data, and any kind of grievances which you may have with your data. You can report that to a company official whose details are typically mentioned in the privacy policy. So your privacy policy becomes a really important document which helps you understand how an organization collects and uses data about you. But at times, these privacy policies are very, very hard to understand because they are full of legal jargon, some of the words you might not understand as an ordinary citizen. And which is why when you say yes to signing up to these digital products and services, your consent is often not informed. It is not a well-educated decision which you make, which is why laws now mandate that privacy policies be drafted in a way which is more understandable for the layman, which is offered in languages, multiple languages, so that users from diverse backgrounds can understand that. So the SPDI rules right now is what companies need to follow. But once the data protection bill gets passed, that will set out a whole new framework for companies. And it's a lot more complex because now once that bill gets passed, we will have something known as a data protection authority. We will have higher compliance levels for companies with certain number of users. We will also have a higher level of compliance in the case of any kind of a breach. So there are also higher penalties in case companies cannot protect data adequately or if there is a breach. So the SPDI rules are bound to be replaced by what the new bill will get passed into. Apart from the SPDI rules under the Information Technology Act, India also has other sector-specific laws that deal with privacy. One such law are the Indian Telegraph laws, which deal with, say, phone tapping, wiretapping. So can the government kind of intercept your communication when you're, say, speaking on the phone? And those such interception or such, if the government can do that in very few cases, say if there is some threat to national security or if there is a potential for some sort of a public disorder. So those laws are separate. They deal more with the telecom infrastructure of India. And again, there is another set of laws which deal with banking and online payments, the wallets which you use like Paytm, GPay. They also have certain privacy regulations which they have to comply with. And this is in addition to the cybersecurity compliances which they have to follow. And given that your financial records, your financial information is sensitive information, the banking laws prescribe specific standards which banks and wallet companies have to follow. And then there are other laws which deal with privacy under the CRPC for, say, search and seizure, things like that. And we won't go into depth on those, but there are a plethora of laws which acknowledge the right to privacy, which call for protecting your right to privacy. But as such, we don't yet have a dedicated privacy legislation. So in terms of why the right to privacy became a debate in India was, you can trace it back to 2010, 2012, when the Aadhaar program was launched in India. Now, the Aadhaar program was launched because there was a lot of leakages in how the government was delivering public services and subsidies and transfers. There was a need for a national identity. While people had multiple identities, like, say, a driver's license or a PAN card or a ration card, what the government wanted to do was to have one unique identity which helps citizens access these benefits, subsidies, and transfers in a very streamlined way, which is why they rolled out the Aadhaar scheme, which involved collecting your biometric information. So you would give your fingerprint and your iris scan, and this would create a identity for you, which you could use across the board. And what the government started to do was it started requiring furnishing your Aadhaar number, Aadhaar authentication for multiple services, right? So while earlier it was only limited to certain government schemes, it was then extended to linking with your PAN card, with your mobile number, with your bank accounts, and which is why there were a series of litigation before multiple high courts about how this is an invasion to one's privacy. And what then the courts did was they combined all these litigations. And in 2013, the Supreme Court started hearing the cases against Aadhaar and why it invades the privacy. So what happened then was there was a need to kind of assess, one, if the right to privacy is a fundamental right, and two, whether the Aadhaar Act is in compliance with this right to privacy, right? Whether it is a violation of your right to privacy, whether it's constitutionally valid. So the first case dealt with, which is the Puttaswamy 1 case, that largely dealt with why the right to privacy is a part of Article 21, Article 21 being the right to life, and whether the right to privacy is a fundamental right. So what the courts determined was that despite there being so much of jurisprudence which acknowledged the right to privacy as a constitutional right, the right to privacy now assumes more importance and should now be recognized as a fundamental right, an inalienable right which cannot be taken away from you. And it said that the right to privacy is an integral part of Article 21, which is the right to life, and the state cannot infringe upon that right. But at the same time, the court also said that this is not an absolute right, not like a right which is not absolute means that there are certain situations where the state can infringe upon your right. So what it said that it's not absolute, but it is subject to certain reasonable restrictions. So it has to meet a certain threshold, or it has to meet 3 tests for it to be a lawful invasion of your privacy. So the 3-step test, and I know it's getting a little complicated here. So what I mean by this is that the court held the right to privacy to be a fundamental right, but it allowed the state, that is the government, to invade your right to privacy in certain situations. And now these situations was laid out by the court, where it said that any kind of invasion has to fulfill 3 tests. One, which is of legality, so that there should be some sort of a law which permits the state to invade your privacy. 2, that law should have a legitimate aim. It cannot just be a random law that is passed to invade your privacy. It should have some sort of an objective. It should have a purpose. And 3, it should be proportional. So the court said that any kind of invasion of privacy should be proportional to achieving that objective. So if you look at this test, the 3-prong test, the next case, which is Puttaswamy 2, it upheld the Aadhaar Act as constitutionally valid, and it did strike down certain provisions of the Aadhaar Act which were unconstitutional. But it said that largely, like overall, the Aadhaar Act meets this criteria of legality, necessity, and proportionality. Because there was a law in existence which empowered the government to invade the privacy. And this privacy was invaded for a legitimate aim, right? Because of streamlining the process for delivering public services. The aim of the Aadhaar Act was held valid, and it said that the extent to which the privacy of an individual or a citizen was being infringed upon towards this aim, that was also proportional. So the collection of your biometrics was proportional to meet this objective of creating a unique identity for citizens and delivering these subsidies and services. So the Aadhaar Act was held to be constitutional, but at the same time, some provisions were struck down. For example, the Supreme Court said that private companies cannot mandate people to furnish their Aadhaar card for, say, your SIM card or your bank account. Those were struck down. They said that it should not be made mandatory even for public schemes, except for a set few. And it said that except for linking it with your PAN card, you don't have to mandatorily link it with your bank account or your telephone number. So the entire chronology of events is on this slide, as you can see. So I think by 2017, the Supreme Court recognized the right to privacy as a fundamental right. And in 2018, the Aadhaar scheme was held to be constitutional, but at the same time with certain provisions being struck down by the Supreme Court as unconstitutional. And a main takeaway of the right to privacy case was that the Supreme Court directed the central government to create a privacy legislation for India. And which is why the central government set up what was known as the Sri Krishna Committee, which was under B.N. Sri Krishna's chairmanship, to come up with a legislation for data protection and privacy. And the Sri Krishna Committee report consisted of various stakeholders who then published a white paper. And this white paper kind of envisaged what a privacy legislation for India could look like. And they did a lot of research on how other jurisdictions regulate privacy, on what kind of data protection provisions consist in the EU GDPR or in the US under various sectoral laws, right? And then it came up with a draft data protection bill, which was made public and which invited stakeholders to submit comments. So this was a very long drawn process over like 4 years almost, and it is continuing even now. So a lot of stakeholders submitted their comments on the draft personal data protection bill. And after the public consultation, the bill was again redrafted and submitted to the Ministry of Electronics and Information Technology. And when it was tabled in 2018 in the parliament, there was a lot of opposition parliamentarians who objected to the provisions of the bill, and they pushed for the bill to go to a parliamentary committee. And this was in light with all of the in the opposition in the parliament, and there was a JPC, or a joint parliamentary committee, which was set up to review this bill yet again. And once the committee, I think that was also once the committee had been set up, then the pandemic hit and there was a little bit of a delay. But sometime last year, the report was finalized by the parliamentary committee, and now the final draft of the bill is yet to be tabled before the parliament. So it has still not been deliberated by the parliament or passed by the parliament, and it's still at the stage of being tabled. The final draft has yet to be tabled before the parliament. So till now, we do not have a dedicated privacy legislation. And though there's been so much of public consultation, so much of deliberation, even within the committees, both the Sri Krishna committee and the parliamentary committee, there are a lot of the provisions within the bill which have been said to be problematic. One example of that is that the government has been kind of exempted from complying with the data protection bill, and this is also in line with the right to privacy case, where it says that if the government thinks that there is a justified cause to invade a citizen's privacy, then it is free to do so as long as that invasion is proportional. So there is a lot of debate still about many of the provisions within the bill. And it's not just about how government collects and uses your data, it's also about private companies, right? And this could range from not just Facebook and Amazon, but also to your Paytm, Google Pay, which has a large user base in India. And these compliances are extremely critical because of the kind of information they have about you and the kind of information they derive from the information you give. So the way you interact on Facebook, the way you use Amazon, you're always getting, say, targeted ads. So there's a lot of data sharing which happens between companies, which is also something you often don't know. A lot of times you might be scrolling through Instagram and you find something and you interact with that ad, and then at the same time you get those ads on Google as well. So a lot of data about you is being mined. These data points, the way you interact with ads or the way you interact with certain posts, those say a lot about who you are, what kind of habits you have, what kind of ideology you have. So the complexity behind data collection, mining, usage has become so high that companies have a lot of power over you. And there have been multiple cases against big tech companies in the US and even the EU, which are taking a lot more proactive action against these companies. But I think India is still catching up to all of these changes a lot more gradually. And without a data protection bill, it becomes really, really difficult for users to exercise their rights in the digital world. For example, I think somebody had mentioned in the chat about the right to be forgotten. The right to be forgotten is in the proposed law right now, but a lot of high courts have still not decided upon whether that should be enforced. So till we get the data protection bill up and running, when we establish the data protection authority that will look over these cases, users will still need to use existing laws to enforce their rights. And it's all become about empowering the user, allowing the user to control the data they share, and to ensure that their data is being protected by any organization, be it the government or the private company, has to ensure. So any questions which we can take?
So I feel before the questions, we have surprise for people who are here in this webinar. And the surprise will just take few seconds and then we can proceed with the Q&A session, Arpita, if that's okay.
Yeah,
All right. So I'll just start sharing my screen with everybody. All right. So guys, thank you so much for joining in today. And this is our small surprise for each one of you. Lawctopus has curated. Yes, so this course basically ties an intersection of law and technology. The course name is TMT Law. Now, what is TMT Laws? It's basically technology, media, and telecommunications. In the past 5 years, there's a huge demand for TMT lawyers. There's a huge demand that a lawyer should, as much as they know law, they should know technology as well. And this is not something that our university or colleges or our law school teaches us. Hence, we have Lawctopus Law School for you, making law digital. So, guys, our mission is very simple. We want to put light on this very interesting field where you can see if you want to build a career in this, whether as a lawyer, whether as a researcher, as an academician. This is something very unique. You could write your thesis paper in it, you could do internships, and TMT is not very narrow. It is huge. There's a huge deep sea of topics that will be covered during the course. The course is super learner friendly. Our team will always be there to support you. And the best part is it is online. So you can carry your law school with you wherever you go. And you will be learning fintech regulations, cryptocurrencies, blockchain, privacy and data protection, e-commerce, media and entertainment laws. This course will also bring not just an Indian exposure of law, but international exposure as well in few modules. And as this course is curated by Arpita herself, who is the speaker of this webinar, and the way this course has been designed, it's the main intention is that each law student should be aware what's going on with technology and law in this new space. Each one of us, whether we want to be a criminal lawyer, whether we want to be a corporate lawyer, knowledge of technology always gives you an edge. Any organization, any bank, or any law firm would admire if you have that extra edge. And with this course, you will have that. So you will also be learning technologies like AR, VR, IoTs as well. And the mode of learning would be very simple. As mentioned, it will be online. There will be live sessions by experts. Yes. And in those live sessions, we will give you a chance to interact with the expert as well. So just imagine the setup would be very same, but you get a chance to speak with the speaker directly. So if you have any questions, you have any doubts, it'll be a very interactive class. It's a very fun learning 1.5 to 1 hour 45 minutes session, which is extremely interesting. And so basically we have 8 text-based modules. There will be reading resources as well, which is again prepared by experts of this field. So not just Arpita, there will be more faculty as well. I will be also teaching something about fintech, crypto, and blockchain. So we'll also be giving you assignment to test your knowledge. We did say you're taking your law school online, but again, this is your online law school and assignments are really important so that you can measure that to what extent you're actually involved and aligned with the course. There will be online forums as well. There will be a discussion forum, and you will have access to the reading resources. You will have also the access to the recorded live sessions as well. Let's say you miss a particular live session, we will provide you with the recording for the same. Also, guys, it's a very we want to support you in the best way we can. It is not a very rigid law school that we have created for you. This law school basically supports the law students or lawyers also who wish to give that extra edge to their career. You could be an experienced lawyer who wants to navigate your career into the TMT space, or you could be a law student who is just trying to expand their knowledge. So guys, if you wish to start this journey, I will be sharing some links on the chat box. So the next step would be very simple. I will be sharing a WhatsApp group link. If you're interested, please join in the group link. Also, the webinar recording, whatever we are speaking about right now, we'll be putting on the WhatsApp group as well. There will be a lot more updates related to TMT, related to this course on that WhatsApp group. The second would be, I will be also sharing an expression of interest form on the chat. If you're interested, please fill the expression of interest form. And another surprise, which is that if you want to start this course, and if you choose to enroll today, until midnight, we are offering a 25% discount on the TMT course to all the learners. So yes, by tonight, if you wish to enroll in this course, there will be a discount of 25% to all the learners. And if you feel that you need some more time, so there is a 15% discount available to all the people who are part of this webinar. Again, I will be sharing all the links on the chat box with proper description, so there is no confusion for you. And if there is any more confusion, you feel you have questions for the course, you have doubts that whether you should go with this or not, so you can simply note down this number. Again, I will be putting this number on the chat box as well, and also in the WhatsApp group for those of you who will be joining us. So Snigdha Ghatak is our career counselor, and she would be happy to help you if you have interest for the TMT course. So guys, trust me, this course is something which will bring a change in your life. You will be ahead of hundreds of law students that go to conventional law schools every year, where we learn topics like corporate law, criminal law, international law. But technology, media, and telecommunication law is something which is very unique. And by getting faculty like Arpita on board, we are also giving you an international exposure as well. So she will be bringing the exposure of USA, and I have done my LLM from Canada, and I will be bringing exposure of what I studied in Canada, and vice versa for all the faculties as well. Again, this will be a very interactive course. This course will actually help you to navigate yourself as a lawyer, researcher, or just a curious legal tech enthusiast in the TMT space. So I will be doing everything on the chat. I will be posting links. Again, if you have any questions, just once this webinar is over, you can simply call this number of Snigdha Ghatak, and all your queries would be resolved. And guys, for the webinar certificate, there's no certificate which will be provided to all of you. However, if you still wish to get a certificate, you can get the same by paying a logistic fee of 100 rupees by clicking this link. I would be clicking this link. I would be putting the the link on the chat box again. So make sure you have your eyes on the chat box as well, as there will be a lot of information coming on your way. And well, thank you so much for listening me, everybody. I will give the mic to Arpita again, and I will just pause my. All right, Arpita, you can.
I think someone has a question in the audience. Their hand is raised.
Yeah, I can see that. Let me. Guys, if the question is related to the TMT course, we would be taking it after once the webinar is over. You can just reach out to us. But if it's related to the webinar, then only we'll be taking the queries. So Dr. S. Kusuma Kumari has raised her hand. So let me just.
Okay, then maybe you can just email Ashna or Shreyankshi if you have any questions. I would highly recommend this course, not because I've created the modules, but I think it's really, it's very relevant to what's happening in today's world. The TMT sector has grown so much that we need lawyers, we need experts who advise companies and the governments to create more responsible digital products and services. A lot of our rights, it's not just the right to privacy that is at stake, it's also about our freedom of speech. It's also about the way we interact with the online world. And now with so many new products and services, especially like say Web 3.0, Metaverse, there are going to be a lot more challenges in dealing with the kind of rights that could potentially get violated. So I think learning about the various sectors is really important, and you need a very nuanced understanding of what kind of rights need to be balanced. And I think this also answers one of the questions I just saw in the Q&A session, where some stores are asking for your name, email address, and phone number for for buying something. And this is the trade-off which you have to assess as a user as well, as to what kind of information you would like to share to receive certain benefits. And especially for private companies, they need some information about you to provide these services. And sometimes these data points could also be excessive. I did see another question about dating apps. Yes, that's also pretty important, because even though your information about your ideological views, whether you want children, whether you are working in a particular company, all of that information is shared even on dating apps, and dating apps have information about you. But again, it's the kind of consent you give to be on these dating apps where you agree to share this information in exchange for finding a life partner, right? So that's a trade-off you also have to kind of assess each time you sign up for something. And usually we don't have that kind of time to go through the terms and conditions and the privacy policies which these apps have. And that's why you have to be a lot more aware of the kind of data you are sharing about yourself, and be very careful who you're sharing that with. And while some of these are made public, like maybe not on dating apps, but like say your Facebook public profile might have a lot of information about who you support politically, or what religion you practice. So the kind of information you share also becomes really, really important. And of course, the information you share still has to be protected by private companies. But the consent you're giving is giving them a free pass to do what they set out they will do with your data in the privacy policy. So make sure that you become a more aware user, so that you can enforce your rights if such a scenario arises. But anyway, going back to the TMT course, please do sign up. Ashna and I both teach different modules, and we have really great curated modules from experts across India. We look at various mediums of technology, not just social media not just social media platforms, but we also look at streaming platforms like Netflix. We also look at telecom. We also look at crypto. So there's a lot to learn, and there is a really large demand for lawyers and experts in this space. So if you are considering to move into this space, it's a very exciting ecosystem to work in. Things change every day, laws are passed every day. So there's a lot to learn from, and also a very lucrative career option. So going back to the last leg of our webinar, let me just share my screen again. Right. So the last thing is what I just wanted to kind of touch upon is the international practices. One of the most robust data protection frameworks at present, which even India has borrowed a lot of provisions from, is the European Union General Data Protection Regulation. It was passed in 2018, and all the companies were kind of given a one-year period to comply with the GDPR, because it was such a huge change on what companies and organizations had to do in terms of compliance. This 1-year period was given to them to transition and start complying with the various provisions. As I mentioned earlier, the EU GDPR has a really large territorial applicability, in the sense that even if you are a company in India and you have users using your product or service in the EU, you will still have to comply with the EU GDPR. And a lot of the provisions from the EU GDPR are also now in the proposed PDP bill. So again, even Indian companies will have to actually companies across the world who are offering services in India will also have to comply with many regulations now. And I think another really important regulation which was passed in 2018-19 was the California Consumer Privacy Act. And this act kind of gave a an additional right to users to opt out of their data being sold by a company. So for example, as I mentioned, suppose Instagram has certain information about what kind of ads you're using. They can be prohibited from selling that information to Amazon. And though this is applicable to companies which are based out of California, which is pretty much a majority of your big tech companies, you have the option to tell them not to sell your data. And this was a really new way to kind of approach data sharing practices. And even though this is not there in the PDP bill, companies which are operating out of California have to comply with it, which means a lot of you also might get the option to choose the kind of data you want to be shared between companies. And these, so even though these were the three jurisdictions we have dealt with in today's webinar, a lot of countries are now creating new regulations to govern social media platforms beyond just the right to privacy, right? So the European Union recently passed their DSA bill, which is the Digital Services Act, which also empowers users to have better understanding of how platforms use algorithms for like pushing content towards you. So again, there are a lot of international practices which are happening, and I think it's really important for all of you to follow these changes and developments, especially because the internet is kind of, it doesn't really have a nationality. It's worldwide and it's intangible, right? So it becomes really important for countries to harmonize their laws and follow what is suitable for their jurisdictions, but at the same time keep up with international developments. And a lot is happening in this space. So like, please make sure you follow these developments, because there is a lot of lessons to be learned from other jurisdictions, and mistakes also which have been made by other jurisdictions, which can be avoided if you are creating new laws for your jurisdiction. And again, if there are any other questions you have regarding the webinar so far, please add them in the Q&A, and then I can take like specific questions.
We have quite a few questions. Shall I start the questions now, Arpita?
Yeah, I think I did answer a few. I saw one on the legality of the Criminal Procedure Identification Bill, which has now been passed, I believe. Yes, so the Criminal Identification Bill has kind of been a part of many attempts by the government to have a central database for criminals, for convicted persons, and it's largely in line with what many other countries do. They have like a criminal database where they can access fingerprints or other information, like very, very sensitive information about convicted persons. But now this kind of extends to not just convicted persons, but also people who have been arrested. So it kind of widens the ambit of the people covered under the act. And again, it comes down to the test which we just studied about legality, necessity, and proportionality. And if this bill is challenged before the court, that's what the court is going to assess. Whether there is legality, yes, there is a law. Whether there is an objective to this, a legitimate aim to this law, whether this criminal registry or this database of information about criminals is going to help in, say, crime prevention, maintaining law and order. If that can be justified, then it could be held constitutional. And the last test is, of course, proportionality, right? Like, what kind of information are you collecting from convicted persons? So as far as I know, this includes fingerprints, iris, even biological information like blood, saliva, semen. So it is intrusive. Yes, it could potentially infringe upon the rights of, say, a convicted person or even someone who's been arrested, right? just because somebody has been arrested, it doesn't mean that they've committed the crime. So you are collecting data, excessive amounts of data about someone who could not even be a threat to public order. So there are questions which have been raised about this legislation. And if it is challenged before the court will have to analyze these different aspects of it. Like, to what extent is collecting information about arrested persons valid? Is it necessary for necessary for criminal authorities to collect these categories of data? Who will have access to this data, right? Like, is it just the police? Is it authorized agencies like, say, the IB or the RAW? So there are many aspects to the bill which have been questioned, and it will definitely be challenged in my opinion.
The next question is, why EU has more stringent laws than India about privacy breach by any big firm?
I mean, see, India is also now on the path of looking at a EU GDPR like legislation. So we are getting there. I think the EU realized a little sooner that privacy is so important, and technology companies have been misusing personal data of users. And yes, it is stringent, and I guess it's called for because of the kind of the way companies are embedded into our lives. They owe a lot more responsibility, or they do have some sort of a fiduciary relationship with users because they're collecting so much of data. And soon enough, like hopefully by this year, India will also have a stringent data protection legislation.
Okay.
There is a question on crypto. Ashna, would you want to answer that? That's not really my expertise.
I feel that we should stick to the privacy law webinar, and for any crypto related questions, please join the TMT course. I would be happy to answer the same. But yeah, we have quite interesting questions coming in. Arpita, do you want me to pick up a question?
Yeah, sure.
Okay, so I think this is interesting. Dating apps these days have started asking very personal questions, which must be stored in their database, which we don't know how it is maybe used, misused. Any thoughts on this?
Yeah, and I think I did answer this briefly earlier, that yes, dating apps do collect a lot of information about you. A lot of it is really sensitive information about your preferences as a person, as well as your identity. Because I know that there is information about your ethnicity, there's information about your habits as a person, like drinking, smoking, things like that. And they do store this data, of course, because of your profile. So again, you need to read the privacy policy of these dating apps to see how this data is being shared. Is it being shared with other companies which could leverage this information about you to, say, provide you targeted ads or any other kind of misuse, right? So it's really critical to understand what kind of data you're sharing on these apps with other people, as well as like what could be. I get that dating apps, the profiles are a lot more private than what is on Facebook, but at the same time, you are sharing very, very sensitive and like data points about yourself. So just make sure you're very careful about what kind of pictures you're uploading, if you're linking your Instagram to it, things like that.
Okay, so they have more questions. All right. My right to information is someone's right to privacy. Is the right to privacy violate the right of information? Interesting.
So again, the Right to Information Act will be subject to the threshold test, right? Like the three-step test. And your right to information about how the state functions is your right as a citizen. There is a legitimate aim for the right to information, right? To ensure that there's no corruption, to ensure that the government is functioning, is carrying out its public functions and duties. So there is the dichotomy, or like there's no kind of the competing rights when it comes to right to privacy and right to information is a little different, and it has been exempt from the PDP bill, I believe. So the government as such doesn't really enjoy the right to privacy when it comes to citizens asking questions under the RTI Act. Though there are certain, though the RTI Act also has an exemption, citizens might not get information about certain topics, like say something related to defense or national security, and the government can refuse to furnish information about such topics if they think that that information cannot be made public. But apart from that, you can ask about government expenditure or how a particular body is functioning. So all of those questions are allowed under the RTI Act, but there are certain exemptions even under the RTI Act.
Awesome. So there's another question. Can companies be legally compelled to provide simpler consent documents, especially suited to Indian users, specifically highlighting in bigger fonts as to what data will be shared by whom and with whom, and how we can control it, like Facebook, WhatsApp, Google, or Instagram, or any other government websites?
Yeah, so that's what I had also mentioned, that the new legislation calls for privacy policies to be made a lot more simpler to understand, because the language typically used in privacy policies is very, very complicated. In order to confuse the user itself, the law will mandate companies to make it available in different languages, easy to understand, so that the users can give informed consent to how their data is being used. And the privacy policies are required to contain certain guidelines and information about what they do with your data. So the privacy policy must have information on the categories of data the company collects, who the data is being shared with, where it will be stored, how the company is going to use your data. All of these have to be specified in the privacy policy. So once this gets, once the PDP bill gets passed, then we will also have such stringent compliance. Right now, under the SPDI rules, this provision which you're saying is not explicitly called out. The current SPDI rules only call for a privacy policy which is in a readable format, which contains information on how your data is going to be used. But the PDP bill calls for a lot more specifications which companies will have to bring about.
So Arpita, do you want to take more questions? Do we have time for some more questions?
I think it's already 10, sorry, it's 10 a.m. for me. It's already, what's the time there?
7:30 p.m.
Yeah, I think let's wrap up. Maybe we can take one more question. And then
you choose.
Yeah. If you have other questions, feel free to email them either directly to me or to Ashna and Shriyankshi. They can pass it on to me. Okay. So somebody has asked about how will proportionality be decided? Don't you think it's a very subjective term? Yes, again, proportionality is subjective, of course, and I think judges have a really tough time deciding that aspect of the three-prong test, right? And the proportionality is also decided based on what is the least restrictive measure. So there is more literature on what proportionality means, and if you go through the judgment, if you go through the Puttaswamy judgment, different judges have kind of explained what proportionality means, and it's kind of the trade-off which you make. It's how you can balance the rights against competing rights, and whether it's just, fair, and reasonable, whether it's the least intrusive measure which the government can use to infringe upon your right. So proportionality also has some sort of like sub-tests to meet. So if you go through the Puttaswamy judgment, you will find what the majority, the plurality judgment says, and also the concurring opinions.
All right. Well, it was quite enriching. To someone like me who is trying to understand privacy, I got to know a lot about privacy law, Arpita, and thank you so much for that. It was not a very conventional way of teaching. You added videos, you added polls, you gave an opportunity for interaction as well. And thank you so much for that. I hope people who are listening this or viewing this in future, you got to know your bit about privacy law. Whether you're interested to pursue a career in this or not, one should know your privacy. It's a fundamental right. This is something which is important to each and every citizen, whether you are a lawyer, law student, or a layman, or a regular citizen. So educate yourself, educate your colleagues, educate your parents. And again, if you're interested, please see the links. I have curated a Google document on the chat box. Please feel free to ask me questions, reach out to me. And yes, enroll for the TMT course. Arpita and I would be happy to answer more questions during the same. And it was an amazing session, guys. Everybody was so interactive, lovely questions, and really apologize to people whose questions we were not able to handle. But guys, I've given my email address. Please note it down, and you can just write me your questions and I'll take it to Arpita. All right. Thank you so much, guys, for being here. Thank you so much, Arpita. Bye.
Bye.